Hello, class. My name is Anthony Kennedy, and I will begin this week's discussion with the term voir dire. This term questions the presumption of innocence and the burden of proof as a requirement in all criminal trials. The purpose of using voir dire in a criminal case is to ensure the principles of fairness. Research has shown that in many instances, a juror believes that based on the fact that a defendant is on trial, it is proof that they are guilty. Voir dire plays a crucial role in assuring that the criminal defendant rights and the Sixth Amendment is honored. A court case without the important clause of voir dire would not assure the judge's responsibility to remove the prospective juror who would not be able to impartially follow the court's instructions, and evaluation of the evidence cannot be fulfilled. The process of voir dire is the questioning of background information of the jurors, the selection or rejection of jurors done by experts. In my opinion, the process of voir dire does not always serve its purpose due to a negative climate already being guilty prior to a fair trial. The jurors sometimes have a biased belief that the defendant is already guilty prior to proving innocent. To create improvements in the current system of voir dire for ensuring of fairness and impartial jurors for criminal trials as a questionnaire system could be created. Without a panel of highly trained, unidentified lawyers to create questions in order to test the vulnerability of biases of citizens whom are called for jury duty. All defendants are entitled to a fair or perfect jury. The due process clause is used during this time frame where jurors are questioned on the process of innocence and the government's burden of proof are beyond a reasonable doubt. These are legal instructions given by judges. This is a process that takes place after an arrest and indictment. The due process clause protects the accused against conviction except upon proof beyond a reasonable doubt every fact necessary to constitute the crime with which he is charged. There are two types of jury strikes. There is a strike for cause, which is when the jury clearly showed a bias which caused disqualifying jurors to be released from jury duty. The strike for cause is decided by the judge. There are only a certain number of premonitory strikes the lawyer can exercise. The strike for any reason except race. The law prohibits a lawyer from striking a juror because of their race.